In this video, I'll explain what is really happening inside the 2026 Florida legislative session and why most business lawyers are not telling you the full story. And by the end of this video, you'll understand 5 major legal changes that could save your business hundreds of thousands of dollars or expose you to massive new liability if you ignore them. Right now, Tallahassee is reshaping the rules for every business owner in the state. New entity structures, stronger non-compete enforcement, an AI Bill of Rights, and a potential constitutional amendment to eliminate property taxes. These are not small adjustments. They are seismic shifts, and the window to prepare is closing fast. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. I've spent almost 3 decades helping corporate executives and investors navigate exactly these kinds of legal turning points. So let me break down what you need to know right now. The single biggest structural change coming to Florida business law takes effect July 1st, and that is the new Protected Series LLC. Governor DeSantis signed Senate Bill 316 into law last year, and most business owners have no idea what it means. So here's the short version. Until now, if you owned multiple businesses or properties, you needed a separate LLC for each one. Separate state filings, separate registered agent fees, separate annual reports. For a real estate investor with 10 properties, the administrative costs alone could run into tens of thousands of dollars every single year. The Protected Series LLC changes that. One parent LLC, multiple internal divisions called Protected Series. Each series holds its own assets, enters its own contracts, and carries its own liabilities. If one series gets sued, the creditors cannot reach the assets of the parent or any other series. This is horizontal liability shielding, and it is now part of Florida law. Now, here's what most attorneys aren't telling you. The protection only works if your compliance is airtight. The statute requires strict record keeping for each series. Fail to maintain clear records, and a court can pierce the veil and hold every series and the parent accountable. Now, if you're managing a portfolio worth millions of dollars, get the formation documents and operating agreements done correctly from day one. Now, let's talk about something that affects every executive with key employees, the Choice Act. The Choice Act went into effect last year, but its full impact is just now hitting Florida courts. Choice stands for contracts honoring opportunity, investment, confidentiality, and economic growth. In plain English, it creates a new category of non-compete agreements for high-earning employees that is drastically easier for employers to enforce. Under the old framework, courts evaluated each non-compete case by case. Was the geographic scope reasonable? Was the time period reasonable? Outcomes were unpredictable. The Choice Act flips that. If your employee earns more than twice the annual mean wage of the county where your business is located, you can lock that employee into a non-compete for up to 4 years. The statute does not require the geographic restriction to be narrowly tailored. In theory, the scope can be worldwide. Courts are now required to issue a preliminary injunction if the agreement meets statutory criteria. So your departing executive can be blocked from competing before the case even goes to trial. If you're an employer, this is the strongest tool Florida has ever given you. And if you are a C-suite executive considering a move, you need to understand exactly what you signed. Hey, quick pause here. If you're finding this information valuable, go ahead and hit that like button. It helps this video reach more business leaders who could use this content right now. And if you're not subscribed yet, go ahead and do so right now so you don't miss the next update on Florida business law. Now, the next topic is moving fast. Senate Bill 482, the Artificial Intelligence Bill of Rights, has already cleared the Senate Appropriations Committee. Governor DeSantis has made this a top priority. So what does this mean for your business? The bill gives Floridians the right to know whether they are communicating with a human or an AI chatbot. AI companies would be prohibited from selling personal user data unless it has been de-identified. And the bill bans government agencies from contracting with AI providers owned by foreign countries of concern like China or Russia. Now, here's the business impact that nobody is discussing. If your company uses AI-powered customer service, AI-driven marketing, or automated decision-making, you could face new compliance obligations. The bill authorizes the Attorney General to bring civil actions under the Deceptive and Unfair Trade Practices Act. Real enforcement, real penalties. Now, the House version has been assigned to 4 committees. That is usually a sign that leadership is cautious. The final version may change, but the direction is clear. Do not wait for the final text to start preparing now. Now for some good news. As of October 2025, Florida completely repealed its sales tax on commercial leases. Florida had been the only state imposing this statewide tax on commercial rent. It added 2 to 3.5% to your gross occupancy cost. Now that tax is gone. If you are paying $15,000 a month in commercial rent, you are saving over $5,000 a year. Multiply that across a portfolio and the savings reach hundreds of thousands of dollars annually. But here's what your attorney may not have told you. If your existing lease still references the old sales tax provisions, those clauses do not vanish automatically. You need to review your agreements. In triple net leases, the tax was passed through to the tenant. If your landlord has not updated the invoicing, you could be paying a tax that no longer exists. This is also a strategic moment for renegotiating lease terms. The most ambitious proposal this session is the push to eliminate property taxes on homesteaded residences. This would require a constitutional amendment on the 2026 ballot with 60% of voter approval. Property taxes currently generate roughly $55 billion annually in Florida. They fund up to 60% of school district budgets in some areas. All right, so why should businesses care? Because if that revenue disappears, local governments will look for it somewhere else. Some analysts project the state sales tax could double from 6% to 12%. That directly impacts your cost of doing business and your bottom line. There is also Bill 105 on local government enforcement actions. It would prohibit local governments from taking enforcement actions deemed arbitrary or unreasonable against businesses. Violators can face up to $50,000 in damages plus attorney's fees. The legislature is clearly shifting power towards the business community. Whether that benefits or concerns you depends on your industry. Let me bring this all together. Talk to your attorney about the Protected Series LLC before July 1st. Review every non-compete agreement in your organization under the new Choice Act framework. Audit your AI tools and data practices before Senate Bill 482 becomes law. And check your commercial leases to make sure you're not paying a repealed tax. And keep a close eye on the property tax debate, because the outcome could reshape Florida's entire fiscal structure. This session is not just another round of committee hearings. It is a fundamental reshaping of the business environment in this state. These changes are already in motion. The business owners who act first will benefit most. Now, if you found this breakdown valuable, hit that like button. It helps more business owners find this information. And subscribe to this channel so you never get caught off guard by changes that could cost you millions. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.